President Donald Trump's Department of Justice forced its way into a lawsuit to which it had no relationship just to argue that employers have a right to regulate employees' off-the-job sexual conduct. The case involves Donald Zarda, a former skydiving teacher. In 2010, Zarda told a female student he was gay to alleviate awkwardness when he strapped her body to his to hurtle through the air. Her boyfriend complained to the skydiving school, which promptly canned him. He sued for employment discrimination. Zarda sued under Title V, the federal statute prohibiting employment discrimination on the basis of sex. Zarda's case has a weakness. Title V prohibits sex discrimination, but until recently sex did not include sexual orientation. In 2015, the Equal Employment Opportunity Commission found that Title V does protect gay people from discrimination. The Seventh Circuit recently agreed. But all other circuits have disagreed, including the Second Circuit, where the case is being litigated. As a result, the Second Circuit brought the whole panel of judges to sit en banc to hear the case and asked DIOC to file a brief. So, when Trump's Department of Justice showed up with its own brief, it was confounding. Making matters worse, Trump's Justice Department disagreed with DIOC, claiming it is perfectly acceptable for employers to fire gay people because they are gay people. Put aside a lot of other maddening parts of this case, that the Department of Justice pretends that being gay is illegal, and that the Supreme Court didn't rule that sexual orientation is immutable, or that the lawyer for the department showed his contempt for the court by taking the fifth to basic questions about internal department decisions. Consider this: the Department of Justice, unbidden, used the weight of the federal United States government to empower corporations to fire you if they don't like what you do and who you associate with while you are out of the office. That is not the act of a freedom-loving American government. That is a lawless act of an authoritarian, and it ought to chill you, gay or not. The Department of Justice, tasked with protecting the equal protection of all people, has jumped out of line to validate bosses who reach beyond its doors into the private conduct of adults regardless of whether that conduct is illegal or affects job performance. That is not American. Of course, absent a contract, no American has a right to a particular job. And there are legitimate arguments about whether Title V covers sexual orientation. Personally, I am ambivalent about whether sexual orientation ought to be read into sex as a protected class under that particular statute. The legal issues are the intellectual questions, parsable in my cortex. For me, the Zarda case is a visceral threat. Zarda presents a federal government that uses the power we handed to oppose many of us, a federal government that represents just a small minority scrambling backward, preferring corporations, conformity and a dark, exclusive religion. In America, opposing tribes and constituencies ought to struggle and scrap. But the Department of Justice ought to keep it impartial, more referee and spacemaker than warrior it is supposed to represent. Me too. It's almost impossible to write about the Trump administration without sounding hysterical. Still, I am horrified by this administration's calm, persistent strides to carve up the rock of freedom until it resembles just a straight, white, conservative Christian man holding a sheaf of stock certificates. Trump has tried to carve Muslims out, Mexicans out, immigrants out, blacks out, Puerto Rico out, gays out. What a disastrous use of our common resources to butcher the body politic and demean the rule of law. Coco Sudak is an attorney and founder of Profit Laws in Chicago.